The topic for the panel discussion today is the fuzzy boundaries of patent law, and the panel discussion will be moderated by the author, Mr. Adarsh Ramanujan.
Thank you. I still had my liquid text file from court today open. Thank you everyone for coming again, and we have a short panel discussion, and hopefully with the kind of intellectual weight we have on this panel, we are hoping to discuss some cutting edge issues within the subject of a cutting edge subject like patents. And the theme may sound a little abstract. It's called The Fuzzy Boundaries of Patent Law, and it's a title that pays homage to Justice Hoffman's observation in a judgment, where he talks about how in many cases when you take patent law claim construction, there are these edges of the document where there is always uncertainty. But as Justice Viswanathan was pointing out, you don't throw the baby out with the bathwater. Just because there are some fuzzy edges does not mean the patent itself is bad. There are some areas of uncertainty that the courts should learn to accept in the domain of patent law. So that's where we are coming. And it's just a very sophisticated way for me to bring to your attention that this is a common word that you'll hear from everybody. Balance is key to patent law. Everybody will say this. Balance is the heart and soul of patent law. The balance is a fuzzy boundary. There are no clear black and white areas when you deal with balance. And the objective of this panel discussion is to see if we are able to get some clarity on this, maybe remove some of the fuzziness from the wisdom of these three members. Now the first question that I want to open the panel with, and this is the big daddy of the questions. Pardon my sexism. Do we really need patents? We've had patents for a long time, since the 14th century, 15th century. We've traced that history. There are also counter propositions today, including from the late Shamnath Bashir, who always felt that maybe there's a different way to incentivize innovation, because there are too many negatives with patent, and perhaps the negatives outweigh the positives. And if you really look at the Iyengar committee report, while he traces the history, ultimately says, well, no other jurisdiction has come up with a better system anyway, so might as well go ahead with what we have. And maybe the future generations think of a better system if there is one. So he left it open-ended. Now, that's a 1959 report, and now we are in 2024. We've seen the world change as if it's nobody's business. I certainly didn't expect to see the world it is today, what I was as a kid, you know. So with that question, I'll open it to Justice Prathiba Singh first. Do you think that patents continue to have any relevance, or is it time that we look at some alternative options?
A very good evening to all of you, my co-panelists and others. Others, congratulations on launching your patent book commentary. And I only wish to say one thing, that the credibility of this author is so high, not because of his surname. The surname does have a credibility. People are going to pass off him with S. Ramanujan. When I wrote my commentary, I wanted others to review 3 or 4 very technical chapters, and he reviewed it for me. So I'm very thankful to others for having reviewed the chapters in my book, and I'm also thankful for you to having me on this panel. So the question that Adarsh has posed is, do we need patent law? Coming from my mouth, if I say no, it's going to be scandalous. Okay, let's analyze it. Do we need patent law? I guess I would follow the reasoning that Rajgopal Iyengar ji gave. There is no other better system for incentivizing innovation. So before we go into this question, my question would be, do we need innovation? I don't think there can be any two thoughts about that we need innovation. Okay, then why would people innovate if you're not going to incentivize it? They won't innovate. You need to incentivize. Why would they disclose it to the public if you don't incentivize. They will not disclose it to the public. They will hold it a trade secret. So what is the better way in which we can avoid reinventing the wheel every time? And that is patent law. And Justice Vaidyanathan has already, of course, got me thinking on AI. Even in my book, we are reaching a high point on patents where now technology is going beyond patents. But patenting is needed for the simple reason that it identifies an entity or an individual as the originator of that invention. What do we need to do with AI, etc.? Maybe there is a need for a sui generis system for AI, but still, as long as there is innovation, patenting is needed. That's my view.
Mr. Vaidyanathan.
Justice Prathiba Singh posed two questions. If there is no patent system, will there be innovation? And second, will it be disclosed? Innovation, yes, there will be. Industrial application also will continue because people, once you innovate, you will certainly try to market it. But disclosure may not happen. So we need to incentivize it, I think, but we need to perhaps, in the light of what has happened, distinction between individual inventors who are not part of a corporate establishment to corporates who have huge funds and to what extent they need to be incentivized. And thirdly, in today's context of artificial intelligence, to what is the kind of restriction that you must have? Because multiple persons could be using artificial intelligence and trying to bring out innovations. I think maybe we need to have a system which will therefore deal with each one of these separately and then incentivize.
Mr. Lall. Mr. Lall doesn't need a mic.
No, not. Usually not. Adarsh, let me first congratulate you on your book. Having recently authored two myself, it is one of the most difficult tasks. And let me assure you to write, because the royalties that you're going to get are not going to be worth your time. So we are very grateful to you having shared that. I'm two serious authors on the subject, so it's a very privileged position that I sit in. I think by the time I leave, I would have acquired a lot more knowledge. Interestingly, I think in this room, probably I've practiced, IP law for the longest, even more than Justice Prathiba Singh, your age. And I'm going to share some experiences of why patenting is important. And I just feel that if, I think that's thanks to my phone. So, it's my phone. So, having practiced for 30 years, largely represented foreign interests in a law firm, I hired the first person. I went to the IITs to hire, we were getting into a collaboration with a law firm, and I'm just going to get in from there why patenting is important. And I went into IITs to hire somebody to do patent writing. And I went to IIT Delhi, I went to IIT Kharagpur, and I said, surely as a premier institute of, where there is technology and you come out with technical people at the highest level, surely you must be having a patent portfolio. And most professors asked me, what is patents? And I was shocked out of my wits. Then I went into interviews and I hired the first patent guy on a technical side, Sujit Thakur. And he later, when he joined my firm, said, I've become the laughing stock of IIT Kharagpur, that you're such a loser that you went and joined a law firm. Now, why am I narrating this story? Because I think as a nation, we've lost out a lot by not protecting intellectual property the way we should have. If Justice Prathiba Singh and others had written this book some time back, we all probably would have benefited from the knowledge. Now, why have we lost out? Justice Manmohan mentioned that over 50% of the patentees, the inventors are Indians. A majority of drug patents are Indians, but not Indian patents. We are a knowledge-based society. I think as a nation, we have not recognized intellectual property as a property ever. We followed the Guru Shishya Parampara, where you give your thumb to your teacher and that's your payment. Money has never been important. And when we look at innovation, when we went to court, even over basic copyrights like film copyright or book copyright, and the judges would say, you know, you're not going to kill somebody for small IP violations. So I think as a nation, we've lost out a lot. We have one of the biggest creative teams which has contributed to the globe, but not contributed to our nation. We are never going to be a nation who's going to have real assets in terms of real property, which is going to be of value. But it is the value of the intellect, and I think it is time that we all recognized. And I think Justice Iyengar was absolutely right. There is no better system. For now, I think we need to adopt it, and we can't reinvent the wheel. I think AIs may need a new sui generis system and not probably part of the patent regime. But as far as innovation is concerned, there is a close link from incentivizing innovation. And the only known way of incentivizing litigation is not patents, but hard cash. And the only place you can get hard cash is by recognizing patents as a property, which can only happen if you file and register a patent and then enforce it and then license it out. So I think that knowledge level to our judges, to our IP holders, to our IP bar, to the general population at large, is a very important ingredient for development of technology.
So if all three panelists believe that we simply don't have a better alternative system, then the question comes is, do we truly have a system that is balanced? Anecdotally, I think many would have heard from the economic side, the Cobra effect. So the British used to have a system to incentivize back in the day that there were a lot of cobras in the country, in the city side, on the town side. So they used to incentivize that if you're able to kill the cobra, you get this much amount of money. So the consequence over a period of time was people used to breed cobras and then kill them to get the incentive. So it's called the Cobra effect in economics. You shift that to patents. Today, have we reached a position where people are over patenting? There are too many patents that are perhaps not good patents. And the particular reason I'm highlighting this is, I think all three of you will know this subject inside out. My observation has been there's a very significant reversal in the trend in jurisprudence, say for example on disclosure norms in the US. The way the US Supreme Court is now reversing the way they used to look at, say, Marcus claims or biotechnology patents. We are suddenly seeing a shift in Western jurisdictions. Have we reached that critical Cobra effect point when it comes to patents, and do we need to tweaking the system? Justice Singh.
Others, I could speak on this topic for at least 2 hours. It's so close to my heart. Okay, let's understand what is the question that Adarsh has posed. And then that will kind of give you an understanding of what is the impact of what's happening. I want to go backwards into the time when the hearing was taking place in the Novartis matter in the Supreme Court. So what was the Novartis matter all about? It was a matter where there was this particular molecule called imatinib. Despite all the criminal law, I haven't forgotten the molecule name. It was imatinib. And in the first patent, Novartis had got a patent saying imatinib and all its pharmaceutically acceptable salts. So that first patent wasn't filed in India because at that time India was not subscribing to the product patent regime. It was pre-TRIPS, pre-1995. It was 1992, if I'm not wrong. So the next patent that was being litigated in the Supreme Court was imatinib mesylate beta crystalline form. The question before the Supreme Court, which went right from the Patent Office till the Supreme Court, was, should the beta crystalline form of imatinib mesylate be permitted to be patented? So the two views were, yes, the beta crystalline form is the magic bullet drug which deals with cancer called Gleevec. The earlier patent was a general patent for imatinib and all its salts and various other combinations of imatinib, which could be about 1 million molecules, but the identified product was this particular patent. So the question that was asked before the Supreme Court was, if you had not identified the product at the time when you got the first patent, how could you even get the patent? Because the basic condition is there has to be novelty, inventor step and industrial applicability, and the first patent should have enabled any person skilled in the art to manufacture imatinib mesylate. Mesylate is nothing but a salt. Beta crystalline form is nothing but a polymorph of the salt. So how could you file a second patent for the same thing? And the research revealed that on imatinib there were 15 separate families of patents that were filed by Novartis, and in each of the patent documents they would say the earlier patented product is of no use, this is the new one, this is the new formulation, this is the new salt. So the question that Adarsh is asking is there over patenting? And India had the courage to say way back in 2013 that there was over patenting in the pharmaceutical field, and at that time we were really snubbed as a country in patent law. We were so snubbed that every seminar I've ever addressed used to say, how could India take this position? This is so anti-innovation. Fast forward 10 years, COVID happened. 3 decisions, 1 from US and 2 from the UK, now take the same position as Novartis. So yes, there has been over patenting in the pharmaceutical field, but the answer is that the judiciary has reined the horse in. Therefore, while patenting should happen as it happens, courts have to be cautious, whether it is in the field of pharma, whether it's in the field of telecommunication, whether it's in the field of chemistry. Courts have to be cautious, examining officers have to be cautious, patent officers have to be cautious that repeat patenting is not permitted. So there's one beautiful judgment called the European Development Central Bank, in which the judge described this kind of attitude of a patentee as an Angora cat. It said, the patentee is like an Angora cat. When it comes to infringement, the Angora cat's antenna bristles and it's very aggressive. But when it comes to invalidity, it's quiet and demure. So the thing is, patentees will do what they have to do, courts have to do what they have to do, patent officers have to do what they have to do.
I think there are 2 major players. One is the patent attorney, the patent draftsman. The second is the patent examiner, before the matter comes to court. In our system, in our patent office, unfortunately I have seen that they are not trained enough to look behind what is presented to them and then really identify what is missing and why more precision should be expected from the patent attorneys, and the patent examiners should tell them. Now, to give you an example which you can easily understand. If somebody claims that this hillock I have identified, this is the Sanjeevani hill. Sanjeevani plant is somewhere there, but I have not identified it. But I am seeking patent in regard to the entire hill. Now, how would a patent examiner grant a patent for this? If he makes that mistake, then all of you judges have to sit back and then analyze and then mercilessly come down on this kind of patenting. And the man who claims that Sanjeevani Hill for patent must have identified, most of the time has identified, wants to use it but doesn't want to disclose it. And then after a couple of years wants to seek a second patent. Now this is the kind of thing that's, therefore, we need to train our patent examiners also, and unfortunately I find very often they don't even know how to draft an order. When some objections are raised, there is not even a considered order. I think this is one area where we need to substantially reskill them and reinforce their training. That's an area which needs to be done, otherwise courts are going to be overburdened.
Perhaps you can also add in the angle what's happening in the telecom space. Is there over-patenting there also?
So, you ask an interesting question. Has patent outlived its utility? The answer clearly is no. I think we are at the threshold of a different level of inventive spirit globally. Not only is there a shift in the pharmaceutical field, the extensive research, even in the telecom field, and now with artificial intelligence coming in, computers now becoming more powerful, patents is only at the cusp of it just beginning to take off. Interestingly, despite this situation, is there over-patenting? The answer is yes. Again, having filed patent applications, how does the pharmaceutical company even work? And I was amazed to hear this. As you're developing a drug, for example, almost every week they will file a patent application, a provisional application, with the fear that whatever I've done till now should not get exposed to the public and I may lose. And you'll be shocked to hear that almost 1,000 patent applications are filed for that same drug, and then eventually you may get that drug which doesn't even work, and all the 1,000 patents are redundant and never used. And I would think on an estimate 90% of the patents are never even implemented or used. But they keep inventing, they keep researching, they spend billions of dollars in that to find that one magic drug. And can you imagine if something between today and a week from now that gets disclosed and you lose out on it? So does the system have the checks and balances? The answer is yes. We've got 4 levels of cancellation: pre-grant, post-grant, as a defense, invalidation claim. Unfortunately, those have to be tested. But be aware that in an expensive patent litigation, no patentee is taking completely useless patents to court. So eventually it gets thrashed out that while the patent office may get thousands or millions of applications, what goes to court is a minute percentage of that after flushing out the good patents. So the bad patents, which is a necessity of the creature, exist. They must continue to exist. And unfortunately, again, my IIT example, when I asked the professor, what do you do with the technology that comes out of your students? They said, we publish it. I said, how does that feed you in any which way? No, it gives us recognition. That recognition doesn't feed you, unfortunately, the patent applications. And therefore, it was a complete surprise to me as to how these companies have a patent attorney walking with their people who are inventors, and at every little inventive step, a patent application is filed. the cobra is never going to be relevant to the so you do kill all the cobras, which are the useless cobras, but eventually you do get a cobra which stings. And that's what I think inventors look for, and that's what the world needs, for that one cobra to sting. The dead cobras can then go into oblivion.
I know Justice Singh has a hard stop, but I want to take one view of yours before you have to move on to your next meeting. We've talked about this balance, and I think all panelists believe that there is over-patenting, but I think the message that I'm also getting is the courts are sufficiently wise enough to ensure that balance is maintained and prevent over-patenting. And perhaps the other message is we need to strengthen our patent office. And on that note, and Mr. Lall was also mentioning, we have this 4-tier system to ensure that bad patents are removed. We have seen a cobra effect in that also. A lot of judgments have highlighted the abusive practices when it comes to oppositions. And in fact, Justice Senthil Kumar Ramurthy from Madras High Court, who was kind enough to pen the epilogue for the book, he has suggested that perhaps it is time to eliminate one of these oppositions, because most jurisdictions tend to only have one opposition system followed by a court revocation proceeding. We have two. He has in fact suggested that it is perhaps time, because the balance is too skewed against the patentee, maybe we should eliminate one. But the message here is we do have sufficiently bad patents to ensure the need for so many checks and balances. So are we on the right track to even consider removing one of these opposition systems? Just your take on that before you have to move on.
When I answer this question, I answer this as an author and not as a judge. With that disclaimer. In respect of most IP, an opposition at the pre-grant stage is absolutely valid, as in trademarks, as in patents. We've always had pre-grant oppositions. The only jurisdiction which does not have it, which I know of, is South Africa. So that's why the AI patent got granted in South Africa. There is no pre-grant opposition in South Africa. So there are two things that I would think is needed as a judge and as a lawyer. We have seen abuse of the multi-tier patent challenging. So I think the first thing definitely that we need to have is a time limit on pre-grant oppositions. Time limits always existed, and I think India went for the overkill when we removed time limits. It can't be endless time for filing a pre-grant. Even in trademarks we have it, we always had it even in patents. It's only after 2002 that we removed it. They should introduce time limits for pre-grant, whatever it could be. It could be 3 plus 1 month, 4 plus 1 month, 5 plus 1 month, whatever. If someone feels 6 months is a good time, fair enough. But the time should be there, it should be never ending. Secondly, after a grant has happened, revocation is always there as a remedy. So having a post-grant as also a revocation and then a counterclaim in a suit, I think is again an overkill. We can do away with post-grants because we do already have a remedy. And 15 years of amendments, post-amendments, India is now comfortable with the patenting system. I think the time has come to relook and to fix pre-grant time limits and to eliminate post-grants. That's my personal view. I'm sorry, I will have to leave because I have a call at 6:30. And it's been an absolute pleasure, Adarsh. And I want to say that I just checked about a couple of judgments in the book, and Adarsh has been very fair. He's agreed where he has to agree, he has disagreed where he has to disagree. So it's a very good thing now that Adarsh has been very frank in his book, and I wish you all the best for more books.
The only difficulty is the authors are still on the bench.
We'll continue the panel discussion. I think this is panel discussion. So in this theme of Now we've covered the over-patenting, possible abuses, and whether we have sufficient protections within our system. The predominant view seems to be we do have sufficient protections, but maybe slight tweaking in the procedure is apt at the moment. But there are two other areas where...
Yeah, I just quickly wanted on these 4 stages. I think the Supreme Court's dealt with it, that if you've been through one, you can't exercise the second one. The only peculiar one that I think needs elimination is the defenses available to a defendant. I find that peculiar because you can raise that as a defense, but you don't necessarily have to ask for invalidation of the patent. So you invite the court to not grant an injunction on the basis of a defense that you've raised and you've successfully raised it, but you've not challenged the patent to invalidate the patent. So I find that a little peculiarity, that the court would say, what? That the patent is not a good one and therefore I'm not granting an injunction, but I'm not invalidating the patent so it can stay on the register? Or is the judge now going to write to the registry and say remove it when no request has been made for its removal? So I think it should be as a counterclaim. I think the pre-grant, I am more in favor of elimination of the pre-grant because it's a 20-year protection, and I think controlling the trademark office is, we all know, is virtually impossible on timelines, even if you give it in the statute. So post-grant and probably as a defense to a suit is probably the way to go. You can always raise that, like in a design, you can always challenge that. That's my personal view, that the defense to infringement should go.
No, I agree completely with Justice Singh. I think we should have a time limit on pre-grant and no post-grant.
Plus one from Madras High Court. So you have a full bench. 2 other topics which I felt are still very fuzzy boundaries. And both these I actually discovered in the course of writing the book. Nothing I realized when I was practicing. This issue of local working. I think we heard Mr. Justice Vaidyanathan, Justice Vishwanathan, so easy to confuse, mentioning this. The problem, the way I see it, is when Justice Iyengar conceived of the patent law in 1959, he made it very specific that it's a new country. We need to ensure that people manufacture here. Because only when you manufacture do people actually get the know-how and the knowledge and the technical skills and the ability. And it is that which will push the country to newer heights. So he imbibed and created legislation where local working was equal to local manufacturing. That was in 59. We implement that in 1970. Then we joined the WTO in 1995. And under the WTO agreement, if you discriminate between local goods and imported goods, that's a non-tariff barrier. And you have difficulties in complying with your international obligations. Which means we undertook an amendment, but I think when we were undertaking the amendment, one portion of the law was amended to say manufacturing is no longer required. But there's an entire chapter, I think section 83 from the panelists will remember, still retains the language that patents are not meant as a monopoly of import, people should manufacture here. So today we have a legislation that seems to be tearing in the opposite directions. And in my view, that's a very fuzzy boundary. And I think judiciary also faces a lot of difficulty, because when we argue interim injunctions, every judge is looking at this as a fact, local manufacture versus import. If the logic is that import should be on par, then should we not have eliminated that section? And yet, if you want to be true to the original intent of Justice Iyengar and the Parliament's intent from 70, we should be pushing to the other direction and insisting on manufacturing everywhere. I think that boundary we have not been able to figure out. Any thoughts on that?
I think in any case, one of the considerations for grant of injunction is public interest. And in the context of public interest, one price at which the product is made available to the consumer in the country is taken into account, particularly in pharmaceutical products. And local manufacture will necessarily mean it will be cheaper. Secondly, I think the courts are entitled to take into account the fact that there is employment generation in local manufacture and keep it as one of the considerations for overall weighing of public interest before grant of injunction. So, yes, the legislature could rectify whatever are the inherent inconsistency in the law which has been pointed out by others. But even if it is done, I think the judiciary, while taking note of public interest, will keep this in mind.
It's again an interesting question. To my mind, patent is a statutory law and we should stay out of economics. Working of the patent and how I commercially exploit it is going into the realms of economics. I don't think we should be pressurizing patentees to be manufacturing in country. I can understand as a nation today, we would want to encourage manufacture, we would want technologies to be manufactured and not imported, but these are purely economic decisions. Reverse this, because we always think, I think, myopically as consumers of intellectual property, not as creators and exporters of intellectual property. But an Indian inventor is now compelled jurisdiction by jurisdiction to manufacture in that jurisdiction to exploit his patent or work his patent. It's just not right. Today, with a global economy, you do not manufacture in every country. Why should you be compelling inventors and patentees who've already been through a hectic exercise of registering country by country, patent by patent in every country, going through the processes of registration, a very tedious one in this country. And now when he's registered it, he should be compelled to now decide on economics, and then if he manufactures here and sells it at a price above a certain thing, you impose compulsory licensing provisions on him. So I think there are sufficient checks and balances, and thankfully the interpretation till now has been in India that working of a patent includes importation, though 83 does have, I don't even understand the meaning of 83.2, of why it's there, what is the meaning of that it's, for, I think it says something like importation, it's not meant for importation or something ridiculous like that. But stay away from the economic exploitation. The patentees already have enough on their plate for economics to step in, and you compel them to manufacture, because I can't even fathom an Indian inventor to go country by country and manufacture in each country, because everybody follows suit.
Thank you. I know we are running short of time, we're already late, but I do want to close this panel discussion with one interesting topic rather. Everybody's talked about AI, and everybody's talked a lot about AI. So we also don't want to be the panel which is again discussing AI, whether they should be owners, inventors. Let that be aside, and Justice Vishwanathan may be right, maybe you have a sui generis register to deal with those. But I want to go one step ahead. Let's assume whoever be the AI as the owner or AI as the inventor, let's imagine a AI assisted invention. So say in a drug discovery process, I employ an artificial intelligence system to eliminate options and hone in on a particular option. So the research that say takes me 3 years, I'm able to do it in 3 weeks because an AI system has assisted me in doing so. The question is, when I assess the inventive step, as the law requires, the patent has to cross the threshold of inventive step, which means it has to be not obvious to the person skilled in the art. The person skilled in the art is one of the most fuzziest concepts in patent law, though we have tried our level best to get some clarity. But it's already a fuzzy concept because it's a hypothetical, non-existent person who is supposed to be average, but yet he knows all the prior art. By definition, he can't be average if he knows all the prior art, but the law says he is an average guy. If you have an AI-assisted invention, you are no longer looking at inventions being done by humans. The assumption of a person skilled in the art in patent law was itself that whatever an ordinary guy can make, you should not get a patent. But now an ordinary guy, with the help of AI, can come up with phenomenal inventions. So if we are going to grant patents for AI-assisted inventions, do we need to relook the inventive step standard? Should your person skilled in the art be somebody person skilled in the art enabled with an AI? or do we still stick to the old person skilled in the art because the person is no longer the same?
To identify the curious mind, because it is the curious mind, the inquiry starts with the curious mind. The innovation starts with the curious mind. So if we have to look at who is the person who had that curious mind to ask the right questions of the artificial intelligence to come up with answers, it's going to be very, very tough. I am not at a stage where I will be able to give answers, but I think the crucial test is going to be how do we identify that person? Because today, we identify the person who, as the inventor, with the available tools, he looks around for answers and then tries to research, make some experiments and then comes up with answers. But with artificial intelligence, multiple persons will be asking the questions. But I think the precision in the question that he raises is what gives the precision in answer and comes up with the right kind of innovation. So I don't know how we are going to identify. It's going to be tough.
So you mentioned in your question that patents are meant for persons skilled in the art. That's not true. A common man can patent and invent. It is only the addressee who's the person skilled in the art. That's the first part. So the person skilled in the art, it should not be obvious to that person, but a common man may come up with something which is not obvious to a person skilled in the art because of the inventive step concept. Now bring in AI. AI at the current level is only a tool. A person skilled in the art with a hammer and chisel is different from a person skilled in the art with an electronic tool to sculpture the same sculpture. So the skill levels are changing. AI assisted person skilled in the art is better skilled than a person who's not AI assisted. Now that brings its own nuances. The moment you bring in AI assisted, do you always check the person skilled in the art and give him the same skill, which is the same AI, and then test his knowledge? Because let's understand what artificial intelligence is. It crunches data at a level which no human mind can match. So it will be able to pull out data, and it's very interesting. Suppose you were to, something not obvious to a regular person skilled in the art, a computer could pull out those permutations and combinations on account of certain connectivity between the two. Let's say in a drug and a carrier, a compound and a carrier in the body, and basis of the protein in the body which carries the drug. The computer may be able to connect that these two will match. But a person at that stage of skill may not have known that these two will match. Therefore, the person skilled in the art who now evaluates it from an AI perspective with that tool becomes a more intelligent human being. Does that invalidate the patent of the patentee who's actually thought it through? The other thing about AI is it will reduce your time. It will crunch data very fast for you. And I am not sure how far the US judgment will hold that AI can't be a patentee, because the person is a human person, not a machine. But the future, the inventions are going to come out of artificial intelligence. Artificial intelligence has the capability and is fast developing. I've just come out with now, I was reading 2 days ago, quantum computing. The qubit is going to now be the new revolution in computer crunching and artificial intelligence, because now it's no longer in bits, ones and zeros, but a qubit has the capability of being 1 or 0 and at 2 places at the same time. So we are bringing in quantum physics into quantum computing, so it's going to become so much faster with lesser use of energy. So artificial intelligence in future will beat human intelligence, because human minds have a limitation of retention, and reproduction of that retention. Whereas a computer will be able to do it. And I think at that point, the person skilled in the art will not be one person, but a series of people, which is also the concept of a person skilled in the art. It could be multiple persons skilled in the art. So the creator of the AI could be one of those people. The person who's trained the AI could be another inventor. And most significantly, the person who's used the AI to pose the question and then get the correct answer. If you go on ChatGPT, it's how you pose the question is how you get the answer. It's how you've trained ChatGPT to answer your questions is what you're getting the result. And the creator of ChatGPT is different from the trainer of ChatGPT. So I think the future is very clear in front of us that AI will be the largest inventor category. And it's time that we recognize the US case dealt with artificial intelligence created Tiffin box. Now he confessed that I wouldn't be able to have created this. It's the artificial intelligence which pulled out all the data and said, how would a Tiffin box hold food longer? Or I think the other one was a beacon light. A beacon light would be more sort of visible to somebody. What AI could do, he could not. Now you can imagine if you have that AI tool and you have a creator of patents sitting in front of you and you pose the right question and it gives you the right answer. Surely that Tiffin box deserves protection if it passes the test of inventive step by a person, not obvious to a person skilled in the art, who's much lower intelligence than the machine that produced it. Surely that Tiffin box deserves protection, but it's not going to get protection because it doesn't have a father, a human father. Or the beacon light is not going to get protection. So how many of these protections are we not going to grant eventually? There was also a NASA, I believe, a satellite, an antenna, which was purely created by artificial intelligence. So the future, I think, but 20 years protection for an AI created, too long. Maybe a sui generis system specifically for AI, which was just Vishwanathan also mentioned. Is there need for patents? Maybe go back to your first question. For AI, maybe there's a need for a sui generis AI related, which recognizes and marries the concept of person skilled in the art as the human married to the same AI which created. And then a disclosure requirement that did you use artificial intelligence to create this patent? What was that tool? What did you feed in? What was the level of algorithm that worked behind the artificial intelligence? And give the person skilled in the art the same level of knowledge. And then carve out what the computer did and then maybe give it lesser. I don't see why we should give it lesser importance if it comes out with something spectacularly new. And then make that sort of complicated decision-taking process of what is new and novel, inventive step, etc. Because I think most AI-related computer inventions will pass all the patent tests. I see no reason why we should not look forward and look ahead. And maybe that's where India needs to take a leadership. Maybe for AIs we can get patents and a sui generis system before any other country, because I can tell you that majority of AI inventions will come through Indians. And I would be thrilled to see India take the leadership position in that, over and beyond what other countries have done till now, which I think are way slower than their thought process than the Indian brain, which is creating the AI globally.
Thank you for that. And in the past, if you look at it historically, we did the same thing with plant varieties. Plant varieties didn't fit within the framework of patents, so we came up with the sui generis system. And I think the general view seems to be that perhaps we should have a paradigm shift and maybe a sui generis system. And I think with that, I know we are overshot our time significantly.
It's only in India we have. It's only in India we have Justice Prathiba Singh. It's only in India we have our friend here as a senior advocate who's a specialist in the field. So there you go. We've got it all. I think we should be the one taking the leadership. And once again, Adarsh, thank you very much for giving us this piece of your mind, your real intelligence through the book.
I want to congratulate Adarsh and see how, being a lawyer, he's asking a question which may even destroy his profession. I mean, whether we need patent system. Of course, he's skilled in several other areas, but he's basically an academic turned lawyer rather than a lawyer turned academic. And all the congratulations and all the best.
Thank you to both the panelists and in absentia Justice Prathiba Singh. Skanda, over to you.
A big thank you to the panelists for making the evening so enlightening. I would now like to request Mr. Adarsh Ramanujan to deliver the vote of thanks.
I'll keep it short. I've already thanked everybody in my introductory address, but thank you again for the dignitaries on the dais. Thank you very much to all the members of the bar, senior members, and my colleagues and friends who have taken the time to come and at least encourage me with this event. And my thanks also goes out to the DHCBA committee who helped me organizing all this. I think Mr. Mathur has had to go, but thank you, Mr. Mathur, Sandeep ji, and Lakshay. Thank you for helping out with all the organizing activity. And my thanks to Skanda, who's been the MC. He's also helped me a lot with the book. Surbhi, who's now in my chamber, and where is Parth? Parth is also here. And anybody who's been in my chamber in the past, who's assisted me in this book writing in the past several years, and all the interns who've helped me from time to time. I'm very grateful for all your assistance, and thank you very much for coming today. And that's it. I think that's my word of thanks to one and all here. Thank you.